Right. A very good afternoon, East Africa, ladies and gentlemen, joining us on this very wonderful Monday afternoon session. I hope you're all doing well wherever you are, and hope the week has started on at a very fantastic note. My name is Gabriel Achaya, and I'm speaking to you from the East Africa Law Society House here in Arusha, Tanzania. And welcome to this very wonderful session on who owns the brief, AI lawyers and the battle for the future of legal advice in East Africa. Now, we all know that across East Africa and beyond, AI is influencing how we work as lawyers. And these developments have presented significant opportunities for innovation, efficiency, and expanded access to justice. But they also raise very profound questions regarding professional responsibility, regulation, ethics, confidentiality, liability, and the future of lawyers itself. So, moderating this session is a good friend, a brother, joining us from Kigali, Rwanda. He's an advocate of the High Court of Uganda and all court subordinates there too. He's an associate at Trust Law Chambers, Kigali. He's practicing in intellectual property, data protection, privacy, and technology at the law firm, where he trains colleagues in prompting responsible AI use, and he also lectures commercial law at the University of Kigali. Now, this gentleman is also a co-author of a book titled Knowledge Distillation in Artificial Intelligence Modules, Intellectual Property Infringement versus Fair Use, that he presented at the Intellectual Property Researchers of Europe conference in Geneva in 2025. He holds a WIPO-founded Master's in Intellectual Property from Africa University. He's also a member of the T. David Profile Piche Association for Privacy Lawyers in Africa and DPO Privacy Center East Africa, and is contributed to the 2026 Data Protection Guide for East Africa. He's also part of the Africa Law Tech Network, where he contributes to conversations on AI and legal practice. Ladies and gentlemen, I'm talking about none other than my good friend, Mr. David Bahige Mutume. Good afternoon, David, if you can hear me, and welcome to moderating the session. I would like to welcome you now to introduce your esteemed panel of experts. Karibuni.
Thank you very much, Gabriel. That was such an elaborate introduction. I hope I am able to do the same for the rest of the panelists, considering the time that we have as well. Good afternoon, everyone. My name, like it has been mentioned, my name is David Bahige Mutume. I'm an advocate. I work with Trust Law Chambers currently in Rwanda. And I've been involved in a number of conversations regarding artificial intelligence and where artificial intelligence is taking us as the legal practice. So it's a privilege to moderate this session, and I will keep my own part short because I think that we have a lot of value with our panelists. So I do not want to also say what Gabriel has said about the session because he has introduced it quite well. First off, the topic for discussion is who owns the brief? AI, lawyers, and the battle for the future of legal advice in East Africa. So the title of today's session asks a deceptively simple question. That's who owns the brief? For most of the history of our profession, the answer was obvious, right? The lawyer owned the brief, the lawyer read the file, he formed the judgment and carried the risk. But today, a client can open a chatbot and receive a memo in 90 seconds. In fact, most times now, transaction lawyers receive contracts that have been drafted in ChatGPT, and the client is simply asking you to review, which is interesting, probably cutting down on how much you have to, how much they have to spend on your hourly rate. So the question is no longer whether the machine can write the brief, because we know it can. The question is who is answerable for it, who the client trusts with it, and what, in a world of abundant legal information, a lawyer is actually needed for. So that is what we're here to work through today. We have 4 exceptional panelists, and we're going to be asking them cross-cutting questions, which run from the economics of practice to discussing what the lawyer of 2035 will look like. I also think 2035 might be a stretch because the way things are happening quite quickly, we may have to consider 27, 28, and 29. So just a simple note on how the webinar is going to run. We'll have each speaker speak on their theme for about 10 minutes. One of our speakers will not be joining us. In particular, that was Aisha, who was supposed to discuss confidentiality and ethics. So in the conversations, I'll have the panelists each speak just a bit on confidentiality as well, so that we have that covered in our conversation as well. And then we'll open the floor to a full panel discussion where I'll just ask a few simple questions directed to the panelists and hopefully in line with what they're going to discuss. And for the audience, please, we'll have a Q&A session after, so feel free to drop your questions in the chat so that we compile them and later ask the panelists to answer them. It would be helpful also for you to direct the question to a particular panelist so that we know who you want to answer, and also that the questions are in line with the conversation that we're having. Yeah, so that being said, and without wasting any time, I think it's only right that I introduce the very first speaker, Kenneth Muhangi, who will be speaking on the end of the billable hour. Such an interesting question, because I think this is one thing that most lawyers are wondering about right now. How do we show our value? Just as a brief introduction, Kenneth Muhangi is a partner at KTA Advocates. He has spent over 15 years at the frontier of intellectual property and technology law, advising bodies from the World Bank to the World Economic Forum, and he has been ranked by chambers and partners since 2022. He lectures at the prestigious University of Uganda Christian University, where I am proudly, where I happen to have studied my law degree. So I've watched him discuss some of his questions for a long time, and I'm happy to hear him talk about it once again. Kenneth, I know you have joined us on the move from Geneva, so let me bring you straight in with a question, if you can hear me.
Yes, I can hear you, David. Thank you very much for the introduction, and good afternoon, everyone.
Wonderful. So, Kenneth, the first thing many clients now ask is, why should they pay by the hour for work an AI can draft in seconds? Is the billable hour finished? And if it is, how should lawyers show their value under the circumstances?
Well, maybe first I'll start with in a market, it's there are very few clients who will there are very few lawyers who will be able to bill by the hour. Most of our practice, or most of our clients, seem to prefer a general capped amount, or even if you have to bill hourly, they'll cap the hours and then they ask you to be able to submit an invoice in that regard. We see that mostly perhaps for international facing clients, those are the ones outside of our continent, but perhaps the experience would be different for my other colleagues on the call. But in that regard, yes, for something that would be done in days. You see, the way that our legal practice works is that the more experienced you are, the shorter time you take, for example, to be able to prepare a pleading, for you to be able to prepare an opinion. And that model still works in the sense that the reason why you find that a partner at the firm will be able to bill much more, let's say, than an associate is because there's an assumption that that particular person who is handling that work has taken a lot of time to be able to handle matters of the same nature, that person has also taken a lot of time to be able to grow that expertise in different ways that expertise can be grown. And so because of that, if you're billing, you consider that then that person would take a shorter time than someone who perhaps would need a little bit more guidance or more review to be able to submit a document. And so in that regard, now, there, of course, we know that that is done even faster. And the truth of the matter is that that human-facing component, which is that if a client would like some work done, for many of the companies or entities that we see, that we work with, that perhaps have an inclination towards hiring legal counsel, they will do so based on the understanding that, one, this firm or this lawyer that is being hired has the experience and expertise to be able to handle the matter. And that number two, even if they were to use AI, ultimately for many of these entities that require someone liable, that should an opinion perhaps be against the law, or should anything have been missed, there should be someone liable. And so in that regard, we will continue to get work. But ultimately, still now within the context of a law firm, if I then receive work and I find that as the senior person on the matter, I am able to give my advice, and then it will depend on a case-by-case basis which lawyer would be interested in perhaps being able to use AI now to be able to handle things like the research, or to be able to refine whatever advice has been given. And so I know as a matter of fact that there are certain law firms or certain senior colleagues that now are saying, no, we don't want to hire junior associates. We just want to be able to do the work ourselves, because definitely that whatever AI prompts, so even if you're to use an AI prompt, with your experience, it's very easy for you to then be able to edit that, to at least refine it to what a client needs. And so in that regard, there is definitely a risk to the younger lawyers in that regard. And I think that's why perhaps at the bar level, it's important now to emphasize these things like mentorships, where even if you do have the capability or means to be able to handle work the way that you can, but still do work with a junior colleague so that you can be able to pass on that work. But that is in regards to preparation of contracts or pleadings. In the much wider scale, especially if you're handling projects, or if you're handling regulatory work, then definitely associates will always have work. Because then that would need you to be able to go to a registry, that would need you to be able to interact with government or with any entity or body that is then tasked with being able to align whatever needs that your client has or wants. And of course, even beyond that, if you then decide if it's dispute resolution, although on the pleading side, a lawyer, although on the side of the pleadings, AI can be able to assist with that, we're seeing that ultimately AI will not be able to appear in court, and it won't be possible if you're busy to be able to attend to many matters. So I think definitely, but even in that context, we still go back to the fact that what now is necessary is that even for those that are learning legal practice, there has to still be a little bit more. I was quite impressed, David, with your CV and the courses that you've done and the work that you're doing in that regard. And I think it is much easier for me, if I am giving work to an associate, to look out for people like you who I know would be able to perhaps understand the assignment, or would be able to add that international context. Which is that perhaps this lawyer has their pulse on emerging topics, on what is happening, all over the world. And so then if a brief comes out, or if a matter is handled, or if a project is executed, it is done so knowing that you have people with, that you're using the right people, the right technical people to be able to handle that part. So in summary, yes, definitely there is a risk, and it's a very, very big risk. But I think that risk is lowered for those that adapt, those that are pragmatic in their approach to legal practice, and those essentially that make themselves dispensable in the manner or way that they do work. So from the contract side, from the pleading side, that risk is even higher. But from the interpersonal side, that risk is lower. And perhaps that is also mitigated, like I said, by the relationships that you build. I think that is what I will end with in that regard, that for the lawyers who have relationships with their colleagues, that are able to, let's say, leverage those, especially from the regulators, and also within the context of a law firm as well, those that are able to handle instructions quickly, and that people that can be trusted, knowing that once work is given to this person, they will do it in a timely manner. Those ones, I believe, will continue to practice law, and AI will be nothing but a tool that they can then be able to use to improve their practice.
Thank you so much, Kenneth. That's so insightful. I like the point. I like the point that the client is still going to want someone to be liable for any wrong advice or any negligent advice that we give. So, in any case, some of the work is still going to remain with the lawyers for those reasons. I also like the conversation about handling this at the bar level and how we should handle it. Some of the things that you're mentioning are definitely going to come up in the moderated discussion, where I'll have a few questions directed to you on that particular subject. But before we move on from you, I'd just like to know, maybe in the different tools that you use currently, how do you protect client confidentiality? Even at the firm, do you require this from your employees, from your associates?
Yes, definitely confidentiality is something that is at the core of our practice as advocates. Even without the use of AI, we know that we have attorney-client privilege. Well, in at least in the context of the work that we do, perhaps not in the wider scale, seeing the clampdown on lawyers that we're seeing in certain countries. But ultimately, because of that attorney-client privilege, it is important that any work that I do it with the confidence that it won't leak or that the public will not be able to have access to it. And so if you're using, so the tools that I use are the traditional AI tools. Perhaps I'll start with a tool like Microsoft Teams or the Microsoft Suite, which essentially then is also AI. And what it does is it will organize my meetings for me. It will organize my schedule. It will make it so that if there are any notes that need to be taken and then extracting summaries, it will be able to do that. So that tool or that suite really helps me to make my work more organized. And beyond that as well, we also use law firm management software system called that also encompasses or uses some AI. Perhaps we are still speaking to the developer to see how those use cases may be expanded, perhaps beyond the limited scope of just being able to organize files, and so that maybe that can even be able to go to to go into things like case analysis and things like that. And beyond that as well, personally, so with those tools, there's already an expectation of confidentiality. I don't expect my emails to leak. Otherwise, if they leak, then surely almost everyone's emails will already have leaked, especially if you're using servers like Google servers. These already are trusted across the world. So if there's a breach, it would be difficult to hold me liable because now it is beyond reality. That is a classic case of frustration, if there was any such case. And so, but outside of that, in regards to perhaps being able to refine my opinion or to be able to edit or be able to do research, then if I'm using tools like ChatGPT, the advisable way forward is to use a paid version, because then even when you look at the confidentiality agreement that you sign with them, it is clear that confidentiality is key, and that security is also key with how that data is kept. They assure me, at least, and every user of that tool, that data will not be shared. And of course, if there's a hack, like I've said, then likely it is a hack for the entire world. But I'm less worried about that, seeing as even when you look at the international scale, really, what would that hacker need with information from Uganda? Most likely, perhaps they'll start with companies where they feel that they may be able to get a lot more out of it. So in that regard, those tools already have, those platforms already have that expectation of confidentiality. But the second aspect as well is that for certain information as well, but this is really more a personal choice, that being that I am also an advocate, a human-centric advocate, but still, and in everything that I do, especially seeing how artificial intelligence is now becoming ubiquitous with every level of society. It is my approach that, there are certain matters really that I won't bother asking AI. And so, especially if it's a matter that has a high expectation or level of confidence, I'll be careful, just to be able to do that on my own and without being able to input any information into any system anywhere. But the truth of the matter is that ultimately, if you look at it from a security platform perspective, even if I think the risk of that data being leaked or shared or hacked, if you're using a paid AI platform, is really the same risk as you receiving those instructions over email. And so ultimately, you find that the servers are as secure in that regard. So for me, I am less concerned with that particular aspect. I'm not sure about the non-paid versions. I don't know whether they have the same expectation of security or confidentiality. But even across, if you look at data that's shared for analytics in many of these platforms, even if it's a free version, you'll find that usually that data should be anonymized. But of course, we live in a world where you don't know what your digital footprint can be used for. And in certain instances as well, data can be reconstituted, even if it is anonymized or even if it is pseudonymized. So it is apparent to us now as legal practitioners that AI is here to stay. And ultimately, it would be difficult for us to be able to now operate at a level that is efficient, or operate in a way that would allow you to be able to handle a number of instructions, at least in the way that we are expected to, without being able to use these tools that now make it easier to be able to review. I think for me, that is the key part, reviewing work. And in reviewing work, AI can definitely make your work better, and can be able to help you be able to have an extra set of eyes, if I'm to use that, the same way you'd have people on your team be able to help you in that regard.
Thank you so much, Kenneth. That's very clear. The point on the tools that you use and the fact that this information is already being shared with some of those servers is quite interesting. If you think about it, it's true. If you use Outlook, you probably have Copilot already connected. In other words, you probably have OpenAI and GPT connected. So at least they have some access to the emails that you receive. If you use Chrome, meaning Google, and most of us run Google accounts, we already have Gemini in Chrome, and it's already helping us draft emails in Gmail, and it's understandable that some of this information is, to some level or to some extent, is already being shared with these servers. So also confidentiality in that regard is quite a complex subject to talk about. But maybe if the audience has other questions regarding that, or they have another way they answer that, we'll listen to them. But thank you so much, Kenneth. I'd like to move on to the next speaker. I understand Ridwan may not be with us. Let me just check that. Ridwan, if you're with us, maybe just let me know.
Hey, David. Hi, Jane.
Oh, hi, Ridwan. How are you doing?
Hear from you again. Yeah, I'm well. How about yourself?
Nice to hear from you again. Allow me to introduce you to the audience. The next speaker is none other than Ridwan Oloyede. He'll be discussing the topic, can a machine give legal advice? Ridwan is a co-founder of Tech Hive Advisory and a director at the Center for Law and Innovation here in Rwanda. Ridwan is a fellow of the IAPP and an expert with the Council of Europe's Data Protection Unit, and he has done a lot to make privacy and AI governance accessible across Africa. Many of us in this space, myself included, have learned in the rooms that Ridwan and his team have built. I've taken part in the Africa Law Tech Network Summit, which Ridwan and his team convenes. And this is one of the reasons that a conversation like the one we're having today feels natural in this region. So without further ado, Ridwan, over to you. Please let us know, can a machine give legal advice?
Thanks for that. I don't know if it's fine to share. I put like something very short together that I can just speak through within the short time that I have, and then please let me know if that's fine. All right.
That's very okay, Ridwan.
Thanks.
Please share your screen.
Great. Appreciate it. Yeah, I mean, very interesting question, and thanks for giving me too much flowers. But yeah, very important and timely discussion, most significantly around, and this also piggyback from what Kenneth has already said. I've already mentioned extensively, and I guess other speakers must also have spoken to this extensively in the beginning. So the key thing here is the conversation is fast changing, the ecosystem is changing. Clients are no longer resorting to lawyers as a first stopgap anymore. I think one of the lot of things that I do these days is people already come prepared with a legal opinion that is created by that has been created by a tool or whatever it is, whether proprietary, whether open source. And they basically just come to you and then ask you to sometimes just validate. It sounds like that, or it gives that vibe. And sometimes it's just, what do you have to say? And sometimes even the opinion that you prepare and they run it through to be sure whether, just so I think, and that also goes or ties back to the fact that AI is also strongly becoming, with the use cases that we're seeing, is also becoming a source of truth when by design or by the way we should use it as professional because of the big confidentiality obligation that sits with us is more like a companion. But now we're also seeing situations where it's being used as a source of truth. It's being relied upon as a source of truth. So clients comes to you with a pre-researched idea and basically wants you to validate. And when you validate, they also go back and then revalidate what you have done. So that's the kind of ecosystem that you have. And I don't know if there are folks in the room as well who probably have had this as their own reality, but that's something I've seen come up a lot in my line of work where people come with, but ChatGPT said this. How come you didn't look at this? That contract they're bringing to you to review, they've also done review, and tools are getting better and really increasingly getting better. So, but the key thing to also keep in mind is how you use it is also very important. So, of advice, but the key is, from a legal point of view, we can still abdicate what our responsibility is. I'm sure a lot of people, use cases must have been discussed before I joined, but one of the incredible things tools can do is to help you crunch or to help us crunch typically long hours of research into shorter insights, where you basically can pick what truly matters and filter through. But what this has also done in terms of empowering us is also just gravitating us towards efficiency. But the key thing now is, where does this really stop? In terms of when you run prompts and then you basically sometimes ask, as a rule of thumb, a lot of people will tell you, for example, that never ask you what you don't have an idea to. And that's also because of the kind of responsibility that we do have as professionals. I was reading a particular blog recently that was talking about how some sort of clients are actually suing their lawyers because their lawyers are dumping proprietary clients' information into AI tools. And it's different if Ken was trying to make a distinction between, when a tool is proprietary or enterprise, which means a lot of enterprise tools that we use these days, typically the ability to train based on what you give to it is most times or often than not turned off by default. But for the free tiers and also the individual ones, not all of them have the ability to turn off things that you train upon it. So in this particular case, the client concern was that the lawyers that dumped proprietary data into the AI tool, which technically, if you're using it to train the AI, it's some sort of disclosure, but the brand of disclosure that is unauthorized because the client did not authorize you to dump it into that. So what does that mean for the future of our profession? Does that mean we need to do disclosure upfront? When you do disclosure upfront and the client knows AI can as well is doing the job you're doing, and the client might as well just build out their own model based on historical, context of what has happened and simply just get you off book. But that's not what the point really is. But then to what extent do we also then rely on this? So AI, yes, run prompts, yes, give something that looks like advice, but do we really call it advice? And I think this is something we need to, because advice, when you say something is advice, it's some sort of judgment. And it's the brand of judgment that also goes with responsibility, especially in our profession. But more significantly is also the kind of duty you owe to the clients, but also the professional obligation that you have, which in many countries is typically also backed by some sort of law, or at least the rules of professional conduct by the bar association in the country or the region. So capability is one thing. Authority, provenance, it's another thing, which we need to be able to separate. So even if the tool is able to help you come up with some sort of a position, it's your responsibility to take responsibility for that. You can technically say something is advisory when you're basically saying it's judgment. What AI does is to produce content based on, whatever context it has, whatever information you provided, and being able to string things together and give you some sense of, what things could possibly be. So eventually, when it comes to the authority to still make a decision, it still comes down to you as an individual. Again, remember the role of duty, the play of accountability, and your legal standing, also the fact that whatever it is you're saying is being relied upon. So, and when we talk about capabilities, basically just talking about the capability of the AI tool itself, and it keeps getting better. We've gone from, generating a video of Will Smith with multiple fingers who couldn't properly pasta to videos being so clean and crisp these days, like so hard to make a distinction between synthetic evidence and what is actually real. And I mean, maybe interestingly is also the fact that a couple of weeks ago, I was in Nigeria training judges, and one of the modules I took had to do with AI generated evidence and a bunch of stuff like this. And this was really one of the biggest concerns the judges also have. Yes, you have to do justice. In Nigeria, for example, relevance trumps any other thing when it comes to determining validity of evidence. So again, it's still very important because part of justice is also being able to filter. But what happens when objections are not made? The lawyers who should do their job are not doing their job. If the judge can see it from far, does the judge have to send to the arena to make a distinction with quite naughty cases like this? But coming back to what we're doing, which is then being able to make a distinction between what it is. We talked about capability of AI tools getting better, but also the provenance and authority, which we as professionals need to make the decision. So the rule of thumb is, and which is like a conversation emerging from a lot of bar associations across the globe, is the conversation should look at a position or a play where we extend unauthorized practice rules to software. So to prohibit, because again, we talk about practice rules, which again, every law society typically have. We've not been able to do that, and we're not doing that to extend to softwares or AI tools, or if tomorrow some sort of another technology comes in. So, but the problem with that is if you prohibit, you also risk limitation. So it's a chicken and egg. And for those in policy, you know what you call the Coleridge dilemma. When you rush to regulate problem, when you're too slow to regulate problem. So when you prohibit, what you get is basically, people can use the use case. But now, because nothing has been done, no one has prohibited, tools are already in the hand of people. People have developed a lot of use cases, which is typically what you call as the wait and see model. So there's all been the attendant risk. A lot of folks who go to court to tell you about hallucination and all of that. Judges are also talking about it. And we're also seeing it coming up, right, even in African courts. So the conversation is, rather than go against the technology, which a lot of folks in policy will also tell you that it's a really bad idea to try to regulate technology itself, for a lot of reasons that we can get to. But the idea is, when it comes to the activity, but for example, can we extend or modernize or shift our rules to, for example, talk about the district where there is use and the extent of use, which is also something you're seeing in the research ecosystem. The quality standards, what's the question about accountability for the and what does that really mean in context? A lot of people, some societies are talking about, maybe we create a sandboxing system, but sandboxes are so expensive. Whether it's innovative sandbox, whether it's a technical one, they are so expensive, and that's a resource a lot of people can pull down. But we're seeing a situation where with low resource, we can actually run a pilot, where we try to use evidence to now determine how we respond, and which is then a challenge to the ELS itself is maybe some sort of guideline for lawyers in the region. Some sort of guidelines are also dumb things down that people can actually make sense of, that can be operationalized, that people can make sense of. So in defining what accountability and liability looks like, talked about the fact that we need to define duty of care, which we already have, but also the question of competence. And this also simmers into conversations around things like confidentiality and privilege. It still says the same. And the rules are still the same. Discipline and complaints, what's the pipeline? What does it look like? Indemnity and compensation, what does this look like? A lot of lawyer firms have like indemnity insurance and a bunch of stuff. If you're doing some onboarding with some clients, they'll specifically also ask you if you have some sort of indemnity clause and to what extent can you indemnify. So what you don't see in this context is that when you're solely or fully reliant on AI, the context becomes different. And that's why, again, it becomes very important that we think through what our response would look like. But just to wrap it up, what should the risk framework look like? What should an AI ethics framework look like? What should an ELAS response look like? What should the National Law Society response look like? And what should we be thinking through as advocates? Definitely it's important to understand the tool before relying on it. Don't ask questions that you don't have an answer to. Remember, confidentiality is sustained. If you're using an AI to individual tool, for example, ability to train is turned on by default, you will be in violation of confidentiality obligations that you have. But it's also very important to, from a supervision and quality control point of view, is to treat it like a junior draft, never a final word. Because that also still gives you the provenance and the authority that we spoke about earlier. But also verification. We've had, hallucination. There is no point really talking about it. Candor, which again is something that is coming up in the research ecosystem, is being able to also admit, you did this, but AI did this to an extent, whether it's about putting in the table or helping with structuring or whatever it is. But also procurement. You also need to be clear about the kind of tools you're using. If you want to leverage open source tools, open weights, gated tools, whatever it is, you need to also be clear about the risks and attendant risks that comes with them. But most importantly is that another thing I think the ELS did this couple of years, maybe last year or so, which is helping lawyers with prompting engineering and, people get better at these things. But I think generally, especially the rules around confidentiality of using AI tools, when they are not enterprise solution, I think that's something that needs to be magnified. That's something that we need to emphasize. That's something that we need to, and again, and ideally a guideline like this those are one of the things I think that might probably help us with. So I'm just going to keep quiet at this point. Thank you very much.
Thank you so much, Ridwan. That was very, very elaborate. Your presentation is clear. I'm hoping that you can share it with us so that we can have even the audience read it in their personal time. For me, I think what has stood out most from your presentation is the part on unauthorized practice, because I think even before artificial intelligence, we had a situation whereby we're wondering, all these people who are building tools for legal practice right now have not gone through the same training and the same bar course exams that these other lawyers have gone through, yet they've already started drafting or building tools that can easily draft pleadings, for instance. So the question is, do they have lawyers who are advising them as they develop these tools? Are those lawyers trained? Are those lawyers holding practicing certificates? What should the rules of the bar course now have to say about artificial intelligence? I think for me that is what has stood out, and I think that's a question that different bar associations are going to have to answer with time. Yeah. Thank you so much, Ridwan. I'm not going to ask you anything on confidentiality because you have ended with it, and I believe we can now move on to the third speaker. The third speaker is Janet Otero. She's discussing the topic access to justice or access to algorithms. It's very nice to meet you again, Janet. We've met at a number of trainings on artificial intelligence, and I'm happy that we're involved in this conversation again.
Nice to meet you again, David. I hope you'll forgive my voice to the people attending. As I share my screen,
just before you continue, I would like to introduce you properly. Forgive me for cutting you short. In the meantime, you can please go ahead and share your screen. So Miss Janet is the managing partner at Coventry's in Nairobi, Kenya. She's ranked by Chambers Global for fintech and telecommunications, and she brings a rare combination to today's theme. She has both built data protection compliance systems, and at the same time, she has won enforcement actions before the Kenya's Data Protection Commissioner. So that practical grounding matters because her theme asks one of the hardest questions for the day: whether AI genuinely widens access to justice or it quietly narrows it. So, Janet, the floor is yours. Access to justice or access to algorithms?
Asante sana, David. A bit of housekeeping. For the sake of Ridwan's employer, Ridwan was not in Nairobi with me. I think there was a bit of hallucination when he logged in as myself.
I saw that.
I am not Ridwan, and Ridwan is not in Nairobi.
That is noted. We had questions. Thank you for the clarification.
So we look at how the justice system is able to just harness and leverage on AI to ensure a level of accessibility. I mean, the conversations that have been there before have always been to the extent as to whether there's adequate access to justice in the way the formal or brick and mortar systems have always been. And just to take you back, like what is our understanding of access of justice? And we're just talking about the ability of people to be able to just sort out or to resolve any of their legal disputes. And some of these abilities may be formally structured, or they may be informal processes they use to be able to either prevent or resolve some of these justice-related needs. And when you're looking at the justice ecosystem, we're not just looking at court, as it were. We're looking at the pathways that lead to this. So the pathways would necessarily be the tribunals, the court system. We are looking at alternative dispute mechanisms. We are looking at legal information. We are looking at law reforms, and all those things are pathways that lead to them being able to access justice. We're also looking at the infrastructure in terms of how court structures are set up, in terms of accessibility to some of these courts, in terms of digital courts and how they're able to access them. The stakeholders that play a part in this whole ecosystem, from judges to advocates to policy advisors to the executive that is able to finance the operations. We are looking at funders, and we are looking at anybody who might be playing a role in just ensuring that justice is able to be delivered. Then services and the data that is usually the output of the justice ecosystem. For most lawyers, some of this data will be in the form of precedents. For some of the funders and policymakers, it will be in terms of how many people are able to access judiciary or judicial services. For other people, it would be in terms of how many courtrooms or court structures exist, how many judges are there. And there's a lot of data that can be harnessed or harvested from the justice ecosystem to just be able to fit in within the bill of giving access to justice to anybody who needs it. So a certain OECD report prints out the hallmark of access to justice as being able to just establish something that is people-centered and that has a purpose and a culture that is able to be identified or to be able to serve the needs of the people who are using this platform. It is also the ability to be able to just design and deliver something that is people-centric and is a balance of what we'd consider legal and justice services. So we are not looking at just a situation where you're building courts, you're hiring judges, but are you able to fulfill the need of these people in terms of what they need for legal services and also what they need as an outcome of them accessing their justice? Then finally, access to justice also involves being able to put up an infrastructure that is able to just deliver people justice, implement policy frameworks, and then still guarantee the autonomy of the bodies involved. I think the previous speakers have all spoken to the fact that what AI does is to additionally supplement what legal service providers do. So if we are looking at it from the aspect of the judicial system, we are looking at it supplementing what the judiciary does without taking away from its autonomy and the position it enjoys within the executive or the justice structure. So once we've been able to understand what access to justice involved and what an ideal access to justice framework or system looks like, then what are some of the use case we see of AI within the justice system? And most of them will tell you a lot have started deploying them for administrative purposes. So when you're looking at administrative purposes, depending on what the judicial is struggling with, most of them will be using it for case automation. Some of them will be using it to sift through the pleadings that have been filed to be able to see whether they meet a certain minimum criteria or they do not. Some of them will be using it to probably generate and allocate cases within certain chambers or within certain specialized courts, and that's purely administrative. In some cases, they use this for predictive and analytics, where they're able to just put in the case and see whether it's able to meet or to generate a first draft judgment, or generate whether it's met the practice guidelines, as Ridwan was saying, whether it's met minimum practice guidelines, or even just analyze some of the outcoming decisions from certain courts to be able to provide a graph or to provide information on what is the outcome as it relates to probably employment and labor matters. What is the outcome with regards to criminal cases of this nature or land cases of this nature? So that's something we are also seeing a lot of it happening. Research and generative, in terms of just going through the pleadings filed, a lot of court systems are now accepting e-filing. So a lot of the documents, a lot of the judicial staff are able to put some of these documents and generate a summary, or help them do research when they're looking at big, bulky documents. So, for instance, in Brazil, the Brazil Supreme Court, they have a tool which they use that is able to just summarize any appeal that is filed, where ordinarily to take a court clerk about an hour to do so, it's taking them less than 5 minutes to be able to see whether the appeal meets the minimum threshold and whether it raises a triable issue for sort of proceeding. In certain cases, they may use it for basically translating or transcripting court proceedings, where we are seeing a lot of language models being deployed. So in certain courts, they're already harnessing this within Europe. They're already harnessing this for purposes of just transcripting and being able to translate court proceedings for people to be able to use. In another curious case, such as in America, they're using some of these platforms for when it comes to domestic violence cases, when it comes to child sexual assault offenses, they're using some of these tools to be able to issue rapid orders, or basically swift judicial action, where a restraining order or certain orders need to be given out in real time. So that's interesting because for some time we've known some of these processes can be prolonged when there's a life at stake. So they're harnessing AI to be able to issue some of these protection orders quite quickly. In certain areas, we are seeing, such as Brazil, Supreme Court, we are seeing some of these tools being used to monitor, to be able to not necessarily monitor, but assess and supervise judges in terms of their output. The situation you're facing in Kenya right now includes judgments, differing judgments that are being issued by judges from the same sort of bench, same division, or cases where somebody is doing forum shopping so that they're able to secure one order in one region, take the case to another region and get a different order or a differing order from a different judge. So Brazil is able to assess the outcome from various judges or various courts to just ensure there's a level of predictability in terms of the judgments being given. And that would be something interesting to see being used in East Africa as a region. So like I said, those are some of the scenarios where we are seeing AI being developed. And just like my previous speakers have said, I won't really spend so much time on this, but these are some of the risks that we see because of what information is fed in there, how you train them, how you ensure that they're able to pick up prompt commands, how they're able to analyze the data that you stored with them as artifacts, and how they are able to explain their reasoning, how they are able to explain their reasoning as a user of these tools, are some of the risks that we are seeing towards the fight by various judicial bodies to completely or fully adopt AI. One of the interesting cases we've seen coming out of Kenya is recently a judge actually threw out pleadings that were drafted by an individual against a state body. And the state body that was actually filing this matter in court raised the issue that this lay person did not retain legal counsel, number one, which is within their right, but also the drafting by this person contained wrong citations of the law and wrong citations of cases. And as such, the judge acknowledged that, but also the judge addressed himself to the fact that we have civil procedure rules that are able to dictate how pleadings in this matter ought to be drafted. And these particular pleadings fell short of those basic rules. But in addition to that, he also said that this particular person was claiming an unfair advantage by being able to use AI against the adversary. On that one, I beg to differ, because it's the same way where some law firms have invested in these tools and they're able to get a competitive advantage in terms of client retention, delivery of service and all that. It feels quite unfair to punish somebody because they've invested in tools that are able to just make their work faster and smarter. But the judge felt that it was unfair that he would get an unfair advantage over the adversary in using tools. But also his problem was also that the person did not disclose the fact that they had used certain or specific AI tools for specific parts of the pleadings. So that has raised a bit of an issue in Kenya in terms of where the judiciary stands with pleadings that are drafted using AI. Now in Kenya, our judiciary has been able to generate a draft policy on AI adoption sometime last year. I think it's still undergoing discussions, not sure if it's been fully rolled out. But the scope of this policy is basically looking at how to adopt and govern AI use in the judiciary so that they use it for basically case allocation, analytics, chatbots for people who may want to raise preliminary issues before filing in court. Document review, transcription, like we said, and also just what they can do around predictive modeling platforms. So again, like my previous speakers have said, the risks they've identified that they really want this policy to govern include data privacy, cybersecurity, which is a risk for most digital platforms, but also bias, discrimination, and also how they can uphold their autonomy when it comes to using these tools to make their work easier. So the following principles as what the policy has laid down, they want to ensure that if they're going to use AI and the judges and the judicial staff will adopt AI, they need a platform or a system or a way in which these tools are able to operate with a level of trustworthiness, as has been agitated by my previous speakers, Ken and Ridwan. But also they wanted to have a level of inclusivity and accessibility. And this is for the Kenyan market, so that it's able to also reach marginalized and vulnerable groups. So I'm thinking this is in terms of its usability and its interactivity. Fairness and bias is quite straightforward. Transparency and explainability is also straightforward. Human oversight, accountability, quite straightforward as well. Those are things that have been discussed over various platforms. Judicial autonomy is where now the judiciary is saying that the tool should not undermine judicial autonomy, and it should be able to operate in a way that it guarantees the independence of the judiciary. Now, my question with this one is, how do you train a tool, or how do you acquire or procure a tool where you're telling the provider that the judiciary reigns independent, and because of that build a tool around that? That's a discussion we can have later on, but that is what I would want to know what the drafters were thinking about, a tool that would guarantee independence. I feel like you have to train it to guarantee independence as opposed to acquiring it with that level. Then finally, which is a good thing that I've seen, they want something that is locally led, something that is built locally, that is able to prioritize local needs and is able to prioritize local use. And they're also insisting on the fact that the data that is used to train these tools is stored locally. So that's a good initiative from the judiciary. The other thing we've seen with this policy is in terms of the governance structure it's proposing. It's proposing something already multi-tiered from the Chief Justice going down to several committees, but it's come up with something known as the AI Governance Committee, which will be an offshoot of something they already called the ICMS. This was the committee that was in charge of deploying the digital courts and the digital filing. So it's going to be integrated within the same committee and oversee AI use or deployment within the judiciary. And just like Ridwan says, it provides for risk assessment for the AI systems in terms of when it's acquired, when it's deployed, and when it's in constant use. It also provides for how to just manage third-party risk if you're going to be acquiring or procuring this from other developers. It promotes capacity building and skilling. And then it also provides a very elaborate plan for implementation where it talks about testing, acquiring, integrating, customizing, and impact assessment from time to time. I've looked at the other East African countries as to whether they have a similar judicial policy. I could be wrong on this. I've seen them pronouncing themselves on the fact that the judiciary would be keen on leveraging on technology and AI. Rwanda seems to be a bit far ahead in terms of a national policy, but I'm yet to see one from the other two countries. So what we are saying in conclusion, and I won't belabor this point because it's been discussed, but it is important that if we are going to guarantee access to justice, in addition to using algorithms to be able to offer seamless judicial decisions and judicial service to those who come seeking, whether from the bench or the bar or policyholder or lobbyist perspective, that any potential bias or inconsistencies are able to be alerted so that we have a human in the loop looking at these decisions to be able to just mitigate against that. What governance mechanisms are there to guarantee the autonomy of the judicial bodies and to just ensure that we leverage on what is existing and build or give guardrails in addition to what is already pre-existing. Also transparency for reasons that has been discussed before, and also just ensure that as much as we are moving towards digital transformation, human rights are not infringed or are not trodden upon, because we know the justice system can be very skewed to those without voices or the voiceless. So continuous assessment is something that is recommended for this part of digitizing. And I will stop there.
Thank you so much, Janet. Thank you so much for your presentation. Quite insightful as well and very clear. The examples that you've given from the various countries and how they're using artificial intelligence to improve access to justice are quite interesting, especially in America. Maybe later on in our moderated session, we'll try and figure out if those particular countries have started figuring out how to also keep information confidential as much as you are allowing artificial intelligence to enter these judicial online platforms. We understand that many of us have them in our countries, and many countries are thinking about how artificial intelligence could be added onto the functions that those systems perform. I think it would be also interesting to discuss confidentiality. I also like the point on the wrong citations that different lawyers give in courts, and the fact that one was caught in having drafted a pleading using artificial intelligence. Maybe in the moderated discussion, I'll remind you to tell us what the consequences for those lawyers were. Maybe this is something that bar associations should start thinking about in their rules for lawyers and how to use artificial intelligence. Yeah, but thank you very much. I won't ask you any question on particularly on confidentiality. I'll keep that for later on so that we can move on to the fourth and last panelist. Mr. Muchibi, I hope you can hear me. Paul, are you
Yes,
there with
David.
us?
I can hear you. You are loud and clear.
Thank you very much. It's nice to hear from you. Mr. Muchibi will be discussing the lawyer of 2035. Just as an introduction, Mr. Muchibi is a Ugandan lawyer, legal academia, researcher, publisher, law reform expert, digital rights activist, human and public interest rights practitioner, and he has over 18 years of professional experience. This includes in legal education, litigation, judicial reform, and statutory development. His work involves intellectual property, human rights, and ICT law, also integrating digital transformation and artificial intelligence into legal and justice policy, as well as legislative development, education, and e-justice systems. He's currently serving as the head of the Department of Law, Reporting, Research, and Law Reform at the Law Development Center, where I happen to do my diploma in legal practice, and I am honored to say that Mr. Muchibi was one of my professional trainers while there back in 2018. It's such an honor to meet you once again. I am happy to hear from you on this conversation, and I will just get right into your question. What will the next generation need that we were never taught?
All right. Thank you so much, David, for that humble introduction. Good afternoon, everyone. My panelists here and our listeners. This is a very great opportunity for me to speak to this bar association, the East African Law Society, on these matters, which I think are very critical for today's lawyer and the future lawyer. I'll begin by giving you two important quotes that summarize my area for discussion this afternoon. And I want you to listen to them carefully. One, the future will not belong to lawyers who know the law alone, but to lawyers who can apply the law in a changing technological world. I can repeat that. The future will not belong to lawyers who know the law alone, but to lawyers who can apply the law in a changing technological world. That is one. Two, the future will not wait for lawyers to catch up. Lawyers must prepare to meet the future. I repeat, the future will not wait for lawyers to catch up. Lawyers must prepare to meet the future. I wanted to have those as opening quotes, and they will summarize my discussion. We are looking at technological disruptions in the legal profession today, and it is anchored with quite a number of features. We have AI, and that is generative AI and agentic AI, how they have entered the legal profession and the legal practice. Matters to do with the legal research, due diligence, contract review, among others, can all be done in minutes than they used to be days ago. Disruption of billable hour, which discussion Kenneth discussed earlier on, has also become an issue where a client doesn't need to come with completely nothing in head to meet an advocate. A client will come having done quite a number of research about the case or the problem. By the time he comes to you or she comes to you, already has some background information. We have cloud-based practice management and corroboration. Things have changed totally. Case filing, case tracking, client communication, everything being digitized and tracked within just minutes. Today, we are having so much to do with the e-filings, e-payments, e-drafting, e-service, e-hearings, among others. All these are part of the disruptions in the legal practice. E-discovery platforms are equally there. Software now today uses machine learning and predictive coding to sort, review, and redact massive volumes of digital data during litigation, which originally couldn't be possible. Today, in Uganda, for instance, use of pseudonymity is a matter of practice, but not a rule of law. You can see a case being filed using case names of a minor, names of, if it is a divorce cause, names of the parties to the cause, whereby certain evidence and what happens is really too confidential, which would have ordinarily required protecting such persons. Some time, I think about around March this year, there is a decision, a judgment that was uploaded on Yuli in Uganda here, which disclosed all the details of a minor, including including his age, where he lives, everything captured in a judgment without even anything like redacting. AI is coming to, and I commented about that decision. I even tweeted it, and I was so happy to see that the judiciary immediately took action. They pulled it down and had to redact and upload it again to protect the confidentiality of such people. All these are serious issues. Then the legal tech startups and alternative providers, we are having so much to do with the startups and alternative legal service providers who are bypassing the traditional law firm gatekeepers. And this is incidentally eating up every firm today. We have issues of blockchain and smart contracts. Before anybody thinks of a client now these days comes to you with a draft. Say, I had something I had initiated. When you internalize well, that is an AI product. So what is this all speaking to? This is speaking to very serious issues to a modern lawyer today and a lawyer for the future. How are we going to survive in this next generation? There are survival strategies that have to be into place. One, we need to leverage poker skills over checker tasks. What does this mean? AI excels at structured, rule-based checker tools like e-discovery, contract drafting, and basic research. So we have to put ourselves in that situation today that without it, we are going to become irrelevant. And we need to set the ball rolling now. Even talking about 2035, like David, you said in your opening remarks, it's too far to me. We already even in the gap. So we should think about 3 years from now. The dynamics are completely changing day by day. We need to adopt hybrid intelligence, combine the speed of AI with the oversight of a human attorney. There is a lot of misuse which the previous speaker has talked about when it comes to use of AI in the legal practice. And incidentally, I think we shall have a chance to talk about later on. Globally, courts have been condemning and lawyers have been hit terribly for professional misconduct when they misuse AI. So, well, as we have it, it is good, it is a tool, but it should not overshadow the human attorney in you. Then transition to digital and agile operations is also critical. Clients today demand greater transparency, faster turnaround time, and cost predictability. So the only way we can fit into these demands is to embrace digital transformation as well as automation. And once we do that, we are going to reach that stage where we feel that we are the lawyer of the technology generation. We need also to cultivate in emerging practice areas. So much of them, the aerospace law is one of them, cybersecurity. Those are very critical areas. We also need to prioritize cybersecurity and compliance, and that involves data protection. Now, what should a lawyer of 2035 be? As the topic is, though I said it is quite far. But a lawyer of 2035 should have the following skills, competences, and survival strategies. I'll just summarize them about 9 to 10. 1, the legal profession is changing rapidly because of AI, digital courts, automation, and the legal technology. That is a fact we cannot deny at all. The lawyer of 2035 must combine strong legal knowledge with digital and AI literacy. Gone are the days of thinking you are going to scratch only the brain in the library, like the years of David at LBC. Only entering that building, that block, we are away from that. You need to combine strong legal knowledge with digital and AI literacy. The other concern is routine legal work will increasingly be automated. But judgment, ethics, advocacy, and client care will remain human strength. So as much as we talk about automation, judgment, ethics, advocacy, and client care will remain the human attorney in you. Meaning, AI is a very valuable tool, but it should not replace your human judgment. You have to combine the two to avoid issues of hallucination and professional misconduct. The other important concern is future lawyers must understand digital evidence, data protection, cybersecurity, e-filing, virtual hearings, and AI-assisted legal research. Those ones today, you cannot avoid. Even the existing platforms we are using, Google, Chrome, all have LLMs Gemini is there, Perplex is there. So there is no way now you are going to exist in this profession without using aid of these. So you must prepare yourself for that. The other is legal research and drafting will still matter. But lawyers must verify AI-generated content, authorities, and citations. I have 1,000 cases where courts have condemned lawyers for hallucinations while submitting in court, while filing submissions, among others. I'm yet to see also the sanctions against the judges themselves when they write judgments and they are full of hallucinations, and the blame is only put to lawyers, but there are also judgments that are full of hallucinated content. And that is something we should all be looking at. Then the next generation must develop interdisciplinary skills by engaging with technology, business, policy, and innovation. The previous speaker has posed a very critical question to me. Well, as Rwanda, Kenya are moving faster on regulatory and legal framework concerning AI. Where is Uganda? Where is Tanzania? This is an issue. Uganda is soon, we had the paperless judiciary being launched on 1st June this year. Paperless judiciary, and in the Court of Appeal, there is a bit of integration of AI in the court processes. But when you go to court, when you do work, you don't feel the paperless judiciary. You are still in the other judiciary. First of all, one of the concerns could be the regulatory and policy framework, which is lacking, and that is something other East African countries need to leverage. As we talk about the East African Law Society, why should some countries be moving faster, others behind? Yet we are talking about cross-border legal practice soon. We shall have issues. Then the other is lawyers must protect confidentiality, avoid over-reliance on AI, and remain accountable for their professional work. Incidentally, in one of the areas of this dialogue we had, there is a question which is very, very critical. Who owns the brief? Is it AI, lawyers, and the legal advice? And my answer is very simple. The client owns the legal problem. The lawyer owns the professional responsibility. AI owns nothing. So it goes back to a lawyer being a profession. You have the professional duty to execute your business professionally, ethically. And where anything becomes a problem, it goes back to you. So that is something very critical. Confidentiality, as the moderator said, maybe we shall talk about it later. The other concern is survival will depend on continuous learning, adaptability, specialization, and responsible use of technology. That is key. We have been telling the judiciary, you are moving so fast with the technology. We love technology, some of us, it is really our area. But sometimes when you are too ambitious, you may make it crash the entire system. Before even your staff appreciate the use of AKVs, you want to go paperless. Before even you have the necessary confidentiality strategies in place, you're already moving to paperless. And we are telling them, no, let us take the process systematically, gradually, but impactful. And that is what we should also be looking at. Then young lawyers should view the expertise in emerging fields such as AI law, data protection, cyber law, fintech, IP, and digital rights. I'm happy some universities have started training lawyers in these areas, which hitherto in our days were non-existent. Perhaps IP, which we are doing in the ordinary way, but now it is integrated with technology, among others. And lastly, the lawyer of 2035 will not be replaced by technology. I want to give assurance to lawyers, because some of them, why they fear even embracing technology, because they think technology is here to undo them. No. A 2035 lawyer will not be replaced by technology, but by another lawyer who uses technology better, ethically, and strategically. So you will exist as a lawyer, but you will be replaced by another lawyer who uses technology better, ethically, and strategically. So the ball is in your hands. Either embrace technology or accept to become irrelevant. I'll conclude with another ending quote. Technology will change the tools of lawyering, but integrity, judgment, and service will remain the soul of the legal profession. I thank you.
Thank you very much, Mr. Muchivi. That was quite interesting. I've picked up on a number of points, especially the competences that younger lawyers are going to need for their careers in the future. I feel your presentation has been right on point. And again, these are all considerations that we should have for 2026, 2027, 2028. Truly glad to hear from you. I specifically liked your coining of the issue as hybrid intelligence. I think that's something that I've not had much. Hybrid intelligence sounds really interesting, and it's on the money itself, because surely we cannot have AI take over without any sort of human touch or involvement. That's true. Another point is on the sanctions for judges. We should also understand that judges are using artificial intelligence in creating judgments, and this is also a huge risk. So when we talk about sanctions, I think it's also important to talk about sanctions in that area. I don't know. I guess then those conversations need to be taken up with the Judicial Service Commission and the other institutions that are necessary. For us as lawyers, I think the question on what East Africa Law Society should do and the rest of the bar associations remains quite an important one, because other bar associations in other jurisdictions are doing something about it, and I think the next conversation should be right on that. So thank you so much, Mr. Muchivi. Allow me to now take you to the moderated discussion, where I'll be posing a few questions to our panelists. Some of them are going to be directed to particular panelists. And in the meantime, I'm not seeing any questions from the audience yet in the chat. Please feel free to drop your questions there so that I can compile them and pose them to the panelists as we go. So the first question, I think, speaks more to Kenneth and Ridwan's presentation. So please, both of you, feel free to chip in. If AI can produce a first draft and the client can read it, what is the client paying a lawyer for? I know Kenneth hinted on this especially, but I think for our audience, as well as Ridwan, by the way, for our audience, what exactly do you feel that the client is now paying for? And especially since they are lawyers, they're really interested in knowing how to increase their value so that the client knows exactly what they're paying for. I think we can start with you, Kenneth.
Okay, sorry, I was trying to find somewhere to be able to talk to you. Sorry,
All right.
could you repeat the question, David?
Okay, so we spoke a lot on how lawyers are supposed to up their game and really show value even in the age of AI. So as we were saying, that if AI can produce the first draft and the client can read it, what is the client exactly paying for?
Well,
or what are they paying the lawyer for?
I guess that goes back to what every presenter has spoken about. Ultimately, what are you using AI for? And even as a client, what are you paying the law firm or the lawyer that you're hiring to be able to do your work? What are you paying them? And ultimately, the answer will lie in the field, perhaps where these instructions have come from. And I guess that's why for many of us, we're still advocating for specialized practice. It does not matter how much AI you use, but in certain fields, there will be a necessity for you to be able to have lawyers that have expertise to be able to give you a more well-rounded approach towards the questions that a client asks. So take, for example, seeing that the world now has, well, not just now, but time immemorial, we've moved towards we move towards a harmonized approach towards certain issues. Let's talk about artificial intelligence in particular. Last week we were with other experts discussing AI and copyright, and now we're also seeing that there's an intergovernmental discussion around consumer protection and digital trade, but that's also focused on artificial intelligence in particular. This is happening in Geneva. And so it does not matter how we use AI, there will still be a need for practitioners that specialize in these areas to be able to, one, formulate policy. And so if I'm representing a client and I've formulated a policy that affects their industry, I will definitely have a lot more input than any AI tool or any AI application. And so my take on that is that the answer, as I mentioned before, is pragmatism. We will only be as relevant depending on how pragmatic we are. And ultimately, there will always be a need for legal counsel. And like I said, even before, ultimately, you come to a law firm to be able to give a view based on you wanting that particular view to have an aspect of liability. That if something was to go wrong, you have someone that you can be able to trust and say, this is the person who gave me this advice, and it is on that standard that I am then taking this action or the other.
Thank you so much, Kenneth. That's clear. I'm about to bring you back because you just touched something. I'm quite curious about the conversations that you're having around copyright and artificial intelligence. Is this and you can let me know if it's okay to ask. Is it now that we're discussing whether whether artificial intelligence can own copyright? Are we creating rules on how the databases that are used to train these artificial intelligence collect information that involves copyright? I'm interested to know where that conversation is going currently.
So the discussions at the moment are ascribed to the liability of artificial intelligence systems, specifically in the aspect of creation, and also in the aspects of training. When these AI systems are trained, are they breaching intellectual property rules or laws? So these are the questions that the world is grappling with at the moment. And Uganda, thankfully, is also part of these discussions. And so we will have a report from the World Intellectual Property Organization, which should come out maybe in about a month or two, which we can be able to share to let you know exactly where we're heading. But yes, those are the discussions around AI, and within the context of consumer protection, it's around the ethical use of artificial intelligence, and really should the member states, let's say, of the UN Trade Conference be able to provide certain guidance in regards to how AI should be used, and in what format or way should that AI be used. So that is really what is being discussed. And so, like at the moment, like I mentioned, I'm in Geneva, just attending that conference on artificial on AI within consumer protection or digital trade.
All right, thank you so much. That's very clear. I see Mr. Muchiwi has his hand up. Maybe he has a question in line with the same thing. Please go ahead.
No, David, I wanted to make a contribution on that question you have raised. In Uganda, we have just had a Copyright and Neighboring Rights Amendment Act 2025. One of my core functions in the Department of Law Reporting, Research and Law Reform is to appear to Parliament, the Legal and Parliamentary Affairs Committee, to give a memo on the bill and certain views. And I happen to have appeared before the LPAC on this bill. And my memo I presented raised some of these issues. Because I looked at the bill, it was very silent about AI. And we already had cases ongoing. For instance, I cited out one collab where a certain individual made a deep fake and made a collab between two artists. What a song of there was Azawi, then the late Mose Radio, and made a collab out of their music and started circulating and getting royalties out of it, whereas Azawi had not consented, had no idea about who this person is, but the person used the AI, and even the estate of the late Mose Radio could not benefit anything out of it. And I presented this to the legislators, and I say, we are having now a chance to amend the law. Where do we leave this? This is part of IP. And how should we really deal with these situations? Because they are increasing even as we talk now. I must report that Parliament took it very, very serious and had to summon entities like UCC. It summoned the NITAO Uganda. It also summoned URSB to dissect this area. The chair of the committee informed me that they came and also gave brilliant views on how they could incorporate certain provisions of AI in the Copyright and Neighboring Rights Amendment Act, which actually the legislators compiled and presented. But when the bill went to the office of the AG, the view that was given was that they need to have a comprehensive law on AI, not having a segment alone on the copyright, which in my view is problematic because AI is eating all industries. It may not be easy for you to say that you are going to have one legislation that is going to govern in the legal sector, to govern in the music sector, in the agriculture sector, because AI is eating everywhere. In the health sector, people are already getting prescriptions on AI. They're having AI doctors prescribing. So for you to think that you have one kind of legislation to address all this, I don't think it was the right position. But I'm happy these discussions are coming, and already people are feeling the pain and the losses. Perhaps we may go back and revisit this position. Thank you.
Thank you so much, Mr. Muchibi. That's quite interesting to actually have a conversation of how to include artificial intelligence in the Copyright and Neighboring Act is very, very interesting. I think amongst the institutions you've mentioned, we also hope to hear from Uganda Performing Rights Society and the other collective management organization. I'm sure they have a lot to say about this because when it comes to the conversation of royalties, we know there's been a lot of arguments in those collective management organizations. I think East Africa Law Society will allow us, and we have a conversation about copyright and intellectual property. Sorry, copyright and artificial intelligence, because that could also take its own separate webinar. Thank you so much, Mr. Muchibi. Now, to bring us back to the question that I had asked earlier, Ridwan, do you have anything to say on how lawyers should increase their value, knowing exactly what the client now is exactly paying for, considering your points as well that they already have these tools and they already know how to use them to draft contracts. So what exactly are they paying for from the lawyers? Ridwan, are you there?
All right. Yeah, David. Can you take that again, please? Sorry.
All right. I was just asking you the same exact question that I asked Kenneth before, to tell us what exactly you think the client is paying for or is going to be paying for, considering circumstances, and the fact that AI is now in their hands and they can easily draft these documents as well as a lawyer would have.
Honestly, David, I think what really in terms of quality and all of that, what's the really unique proposition that I think we as lawyers really bring now, it's just the authority. Because if it's the research, if it's the, what are the step-by-step procedure for setting up in a new market, this information will come clear and clean, the authority to engage and all of that. But I think one unique thing is still the authority, which, you're basically staking your own reputation and your own professional competence on the line to say, you know what, this is the position of the law and I stand by it. So when there is like a fallout or anything, okay, we actually got the help of our lawyers. We didn't rely on AI. That's one bit. But there's also a lot of the human components where we can automate our way out of. So again, exercise of judgment, exercise of discretion, being able to, for those who use like agents, for example, for legal work, I can't use certain words, but it's incredibly good, if I can say that. So, David, you probably know what I'm talking about. How you can, you have your system somewhere, you have your mobile phone somewhere. For those who use like Cloud Dispatch, for example, you're basically asking it to run a lot of things, and you're not literally, you're not like doing an actual prompting. You're basically just asking it to run it on your computer while you're away, and it's setting up, doing all of these things, taking hold of your whole computer, sorting out your files, cleaning insights. Really incredible tools, by the way. So, but I think the point really is one, the provenance authority, but it's also like the human facing components where we really can, automate our way out of. And I think those are like the I won't say last refuge, but like the refuge for lawyers. But when it comes to the core work itself, being able to summarize things, they summarize way better than we do. They write, you literally sound concise. You do all of this. It helps you with like really, really lot of things, like so give you some sort of superpower to do things, quicker turnaround time and all of that. It also brings down our cost, by the way, because we have law firms, for example, that have been able to automate away their comms teams. Because now you can do your own design track without having to beg a designer that you need a flyer to be ready on time. So we're also like automating a lot of what we're doing too. So in as much as, the profession sometimes also has like the vibe of gatekeeping. But there are things we can't gatekeep our way out of, but there are also things we can automate our way out of. And I think whatever those things are across our different markets, it's also very important that we get better at them and also have these tools also help us augment, delivering even more efficiently on those things. But with the way things are going, I'm not deluded to think the tools will keep getting better. That's for sure. It's going to keep getting better, and we're not even scratched. So many use cases of what AI could still do. We've not scratched the entire surface. And there's still so many surfacing that we're going to do. So for me, I think two things. The things we can automate our way out of, but most importantly, authority. Thanks.
Thank you so much, Ridwan. That's very clear. Yeah, an authority over them is really, really, really important for us. Because of time, I'm going to try and move us along in the questions that I have prepared. I see in the chat we still have no questions. Again, for the audience, please feel free to drop your questions there. I will keep checking to see if there are any that I can direct to the panelists. If there are none, I'll stick to mine. I have a question for you, Janet, and maybe considering how I had Mr. Muchibi also talk about policy, I think you can also jump in on this particular question. So, Janet, I had you talk about the policy that's being introduced by the judiciary in Kenya. I don't know if you said the judiciary or the Supreme Court in particular. Correct me if I'm wrong. Yeah.
Judiciary,
So,
the entire judiciary.
okay. Yeah, thank you. So, what exactly is for in terms of confidentiality? Is there anything in the policy that we may maybe concentrate on? And also, maybe one important question is that I see a number of policies are being introduced by different players in the legal sector. So, if the AI policy in Kenya for now is introduced by the judiciary, what does the Law Society have to say about that? Should the Law Society have a different policy as well? What about the other institutions as well? What about law firms? Should they wait for policies from the bar associations, or should law firms as well have their own? I think for Africa as well, we are having issues because on the side of Rwanda, the AI policy is introduced by government itself. On the side of Kenya, it's being introduced by Kenya judiciary. Do you see that as a problem? Is there a way we can maybe combine all of them? Do we need to combine all of them?
You're absolutely right. So in Kenya, we don't have a national policy yet. We have an AI strategy, which was rolled out by the Ministry of ICT, the ICT Ministry. But what happened with this AI strategy, it was just talking about opportunities the government could leverage on to drive certain agendas of the government, such as housing, manufacturing, healthcare, education. So how they could use AI to just drive those agendas. There was no reference whatsoever made to the private sector or other sectors. Then it ended with a remark such that the ministry would build capacity towards putting in place a national policy governing AI or legislation governing AI. So that has not happened since last year when they rolled out the strategy. And like we know, strategies are usually very politically driven because the next government that comes in may not align with that strategy. So we may have to start over again. We've had 2 attempts at draft bills towards governing AI. Again, fell totally flat because there was no stakeholder engagement across board. One of it was, I think, a politician looking to survive. It had political undertones because it targeted, like Mr. Mukibia said, deep fakes, reporting, news channels, and all those things. So it was politically motivated, and that's why it didn't see the light of day. What the judiciary has tried to do, and this I think is coming after what they've seen lawyers do, but we recently had an embarrassing case where I think the Court of Appeal issued a judgment, and Court of Appeal usually have judicial researchers. I think one of the judicial researchers of the Court of Appeal judge did not do their research very well, and as such cited wrong cases, and the Court of Appeal went to issue out this particular ruling or judgment and had to embarrassingly recall it because it contained a lot of errors. And I think it's based off that and the embarrassment that lawyers have exhibited in court that the judiciary has just come up with its policy governing internal judiciary staff and judges. Part of the comment is made is to say, and even with the judgment where the judge was saying that the party was not using AI properly, was to throw it back to the Law Society as well, number one, and to Rules Committee. This is the committee that governs the relationship between the court and the bar bench, to come up with rules and to come up with a framework and to come up with guidelines which can govern how lawyers use AI and how they interact with the judiciary that may be using AI as well. So it's a sort of a joint practice note. So at the moment, we have nothing. Then we had another body come up with how they'll issue certification for AI tools and AI products. This is our standard certification board. Again, very skewed towards what its mandate is. So we are pulling in 10 different directions as Kenya, I can tell you. We have nothing concrete. At the end of the tunnel, there's no light shining. Like Muhangi said, we are now just waiting to see which shoe will drop first. We don't know which direction we are taking as a society, as a practice society, private sector, government, other regulators. We don't know. We don't know. We're just taking it a day at a time.
That's well understood, and at least something is being done. So we commend Kenya. Mr. Muchibi, I want to bring you in on this. Considering your work in law reform, especially for Uganda, and your point that Uganda hasn't yet done anything, in your opinion, where do you think discussions for policy, especially when it comes to artificial intelligence in the legal profession, where do you think it should come from? Should it come from the Law Society of Uganda? Should it come from the Law Council? From the lawmakers themselves?
Okay, thank you, David. Janet has really discouraged me a bit. I thought Kenya was doing very well. I've been following the progress of their policy, AI legislation, and at least they have hands-on, unlike our side. But going back to the question, I would prefer a hybrid approach. One, we should have a national AI policy. Then we move to sector or specific organization policy. Why? The national AI policy is very critical because it establishes the universal human rights, ethics, data privacy, and broad innovation infrastructure. So that when we go to sector specific, we are going to leverage and customize borrowing from the national policy. What we are having here is to hear different entities trying to come up with the policies without a guiding national policy. We started hearing about the Ministry of ICT and National Governance in Uganda talking about the AI policy in 2023. I've been following it critically, very critically. And the last time I checked was early this year in March. What has been already done is to establish a steering committee to start hatching ideas on how we should have a policy or in this area. I think this is quite a lot taking us too slow, because AI is being used everywhere in education sector, agriculture, industry, health, legal, etc. But there is no guiding national policy. My thinking was, and the last year when ULS organized an AGM, it was a tech fest event, only tech fest, and we managed to secure the attendance of the commissioner in the Ministry of ICT and National Guidance. And this is something we're talking about. You could see really there is no clear direction. There is no even preparedness. Sometimes I tend to think, is it that AI is being feared? What is happening? Because the use is already taking place. And the unfortunate part of it is the misuse, which is going to terribly take us somewhere not we want to be. So we would think that if government fast tracks the national AI policy, now other institutions like judiciary, talk about the bar associations, because like law society, if you want to have how regulate law firms use of AI and what have you, when there is a national policy, you can easily customize. Even the judiciary can easily come up to that direction. Recently, I saw in India, they came up with a policy only for the judiciary on how to use, but at least they are benchmarking from the national AI policy. So having it in a hybrid format can help us reach somewhere, and also avoid having sector-specific policies that are not aligned to the national policy. Or when you come up with a national policy, then the different institutions are going to go back and revisit, like research. We've been doing research now, academic research. How much of AI can be used in, for instance, a dissertation? We've been talking about TNT, Turnitin. But now if you come to AI, are you going to stop learners from using AI in research? You cannot. But how much should they? That needs a policy. And the policy should also come from what the national policy has guided. So my view is that we need to have a hybrid, and government is better suited and positioned to fast track this, then other sectors can benchmark from there. Thank you.
Thank you very much, Mr. Muchiri. You've also highlighted a point that I wanted to take us to on the next question. And so I'll bring you back on it first. You've talked about school, and I think this is a question that most of the people on the call or on the webinar are trying to figure out. Many people try to ask, which tool can I use to humanize my AI-generated coursework? Which tool can I use to humanize my AI-generated dissertation? These are things that are happening now. I'm wondering in schools, and I think Kenneth as well, you can come in on this. What exactly are you doing currently to, should I say, stop them from using it, or are you allowing them to use it with some sort of limitations? How is it at Law Development Center now, Mr. Muchiri?
Well, thank you. I dabble at LDs and also universities. I'll first talk about how it is done at the Universal Technology and Management University, which is predominantly a technology university where I teach AI and the law. We can never at any time there stop students from using AI in academic research. We just have guidelines on how to use it. And also disclosure. When you use, you must disclose the content you have used AI. How much have you used? You have to have that disclosure on your coursework that a certain part I've used AI, but also maintaining that you are not merely reproducing what AI has given you, but you must show that you have customized them and also apply your human intellect. So there are limitations, but as I said, this is not yet a policy. We are just working under guidelines. And the danger with this could be when legal challenges come up, you can even be sued and challenged. Or what is the basis of this basis of the guidelines? It can be a challenging question, situation for LDC. Currently, no use of AI. We are not using it at all because you know how the backhouse runs at LDC, predominantly carrying files, perusing files, giving memos based on those hardy files. So LDC is still far away from AI. But I'm saying that is not what we should be doing now. We should be hatching down ideas. But I know most universities have developed guidelines on use of AI and how it should be used. But also, it's important to note, for instance, I was reading on the University of Cape Town, those for them, they don't allow you completely. You're not supposed to use AI in certain assignments. The assignments, they may be permitted, but the assignments, you are strictly not allowed to use. So that type of confusion here, their standards not being the same is a bit challenging. And that's why I'm saying that if you have a country has a national policy to guide, then it will be easier to manage other industries, including the education sector. Thank you.
Yeah, thank you very much, Mr. Muchiri. That's very clear. It's true. Most of the work at Law Development Center is quite hard copy. I'm sure the students also have so much to say about this because surely they're also trying to figure it out. I don't know if Ridwan, you have anything to say on this point regarding education.
I was again, when I was doing the training with the Nigerian judiciary, I was also I had like a professor of data protection. I mean, he's been talking about data protection as far as 2012. Who, we had this really nice engagement, and he himself said, I use it as a matter of fact because it actually helps me. But I think the interesting part about what he said is the fact that I think we can take it away. It's a choice whether if you want to, if you don't want to use it, that's fine. But it's very important that, and I think it goes back to the question around integrity and being able to also disclose the extent of use. And in the spirit of also talking about disclosure and being open, like nobody should be able to shame you into using it. I think that conversation has moved past that bus stop where people shame you for using AI, for example. So it's being able to disclose. I mean, I had to do a presentation, for example, and I had to use Claude Design, for example, which is an incredible tool, by the way. All I needed was, okay, this is how I'm thinking about it. Just lay it out this my way. This my company's template. Put it in this particular template for me, and that's it. So I think, but the most significant thing is again the integrity to be able to stand by it. Because at the end of the day, if there is beans in what you're putting out, and it's there, you also have to accept you're taking responsibility for that. And that's like the part that is really, and I know it could be annoying, especially as a reviewer, where you look at articles and you just read like you're reading slops. So there are people who actually use it so badly as well that, and it's tiring reading slops, yeah. But I think the conversation have moved past whether we can or not. It's now whether, how much of it are we use or how much of disclosure can we do. And I'm not a big fan of AI-based plagiarism checkers. They are horrible. And that's because time and time again, you've seen it, whether you're a native speaker, whether you're a, folks like us who had to learn this language. We've seen it flag the American Declaration for being plagiarized, for example, for being AI generated. We've seen it flag biblical verses for being AI generated. So these tools are also not perfect by themselves. So again, it's an ongoing conversation. And I think it's just very important we don't shame people for using, but rather how can they use well, how can they use responsibly? But most importantly, people realizing the fact that authority, it's very important. You take responsibility for whatever it is that you put out, and whatever it is that happens from there, you also have to bear the brunt. Yeah, thanks.
Thank you so much, Ridwan. That's very true, especially on the point of disclosure. And having said that, I find that your presentation was very well designed, by the way. So thank you for letting me know where to go to create presentations like that. Those of you who didn't hear, Claude Design is a good tool, so you should go and check it out if you want to create a presentation like Ridwan's. Thank you so much for that disclosure. I think disclosure is very important, especially for lawyers. The fact that we use it is obvious. The fact that we should not shun away from the fact that we use it is also another point that I think we are slowly talking people into. Because as soon as someone says that's AI generated, there's some clients who will automatically feel that they're getting less work or less effort from their lawyer than it should be. And I think on both sides, we have to have that conversation. So thank you so much. Mr. Muchibi, there's a particular question for you in the chat, and I think it will be the last question for us in this session, so that we can then listen to Gabriel, who will help us close the session. The question is from Shifra Tuhaire. My question to the panel, particularly to Mr. Muchibi, from a law reporting perspective, and David as our moderator. We all agree that a generic chatbot cannot and should not give legal advice. But as the legal fraternity faces this disruption, how quickly can our regulatory frameworks shift from policing individual chatbots to certifying regional sovereign AI infrastructures? Specifically, if an AI architecture is engineered to bypass generic guesswork and connect directly to official legal databases to provide verified clickable citations, how can our regulatory bodies support builders in ensuring this technology actively upholds data sovereignty and the independence of the judiciary rather than compromising it? I'm asking as a lawyer who's building in the robotics AI arena. I don't know if Mr. Muchibi, you've seen this question in the chat. I can give you maybe 2-3 minutes to consider it.
Yes, David, I've seen it. Actually, I was reading as you were reading through it. Thank you, Shifra. I think Shifra has been following us since we started. That is good. And the nature of question she has raised can easily prove so. We still have a very, very big challenge. There is something you have hinted on, David. If, for instance, I write written submissions to court, court has given us directions, etc. file submissions, and I prepare my submissions using AI, but put my human intellect there to certify the sources, verify the citations, etc. And I make a disclosure that I used AI in preparing these submissions. In Uganda here, my dear, that disclosure, which is ethical in use of AI, but in the mindset of our judicial officers, once they see such a statement, the first thing to run in their mind, this work is all AI, nothing. So we still have a bigger problem to deal with, the mindset. In management, it's change management, I think. First of all, we need to have an institution that is embracing what we are talking about. And the staff should really appreciate what we are talking about. I've interacted with some judicial officers that even have failed to embrace the small tool called the ECMIS. And they are saying, for us, we cannot use that. We are old school. So the moment you submit and forward that to court and put that disclosure alone, it can kill the appetite of a judicial officer. And that drives some lawyers to act unethically, where he has used the AI and refuses to disclose, because he knows when he or she discloses, he is already biasing the judicial officer, and that will be at the detriment of this lawyer's work or the client. That is the starting point. Now, Shifra is taking us to even another higher level. Do we have most of these AI tools we are having, let's say ChatGPT, the Gemini, Perplexity, what? Do they have proper link to the right sources? For instance, what about if you come to let me use the Ugandan context. We have the largest repository for our decisions as ULI. Most of our cases are on ULI. But I've always asked a question. Does ULI sieve when it is uploading those cases? You even find a wrong decision uploaded. So if you ask ChatGPT an authority in that area, and ChatGPT is going to trace and go to ULI and get that decision, and even avails you all the source to link you to the source, which is a very good verification procedure. The question is, have you got the right authority to apply? You are probably citing a high court decision, which was determined per curiam. Now, it also creates the biggest question. Do we have reliable and authentic repository that AI can rely on? The data sources, are they in existence? If we come to the legal profession, we are going to look at legislations. Those ones may be a bit easier because they are there. But when it comes now to judicial decisions, which are key and very critical in our practice, do we have a clear repository where AI is going to have data to rely on? That is going to be a biggest question. I must say that the few that exists have strict attachments. Some require subscription. People have not subscribed. AI, which is offering free services, may not access some of those. So there is a gap there, which is going to cause a lot of problems. But what Shifra is suggesting, it would be a better recommendation if we are really planning for the ethical and professional use of AI. We need to have like service providers. We know that if I visit Kenya Law Reports, I'm sure the decisions there are really decisions that are uncontested. When you rely on it, you are relying on a proper decision that will convince court. We need to have that kind of level. But now, some of the AI service providers that can do that may be quite expensive again, whereby the users again may not have access to them. Like when you want to use cloud can give some of the best sources and linking you to the right sources, but it is one of the expensive tool to be used. So what Shifa is actually suggesting is something that can be actually a policy issue, in my view, which we can think about that if we're to have responsible, professional, and ethical use of AI, how do we anchor this? And how do you put in place strategies to have it? I think her question anchors into that direction. And that is something we are trying to discuss here on a daily basis. How do we move there? But we see faced with a very, very bigger problem of the old school. And you find that the old school is dominating these institutions. So it is slow to pick up. Yes, it is the decision maker. So in most cases, when you bring an idea, but you people, you young people, you are very ambitious. So they would want to get a bit slow and leave, forgetting that it has already eaten us. And by the time they will know that it has eaten us, they're already sanctioning people. So this is something I think as a law society, we need to push as the East African Law Society, but we need to also push forward and see that we have clear policy framework or regulatory to guide us into this direction. Thank you.
Thank you so much, Mr. Mushivi. That's been well said. I should not add on to it or dilute it. I hope, Shifa, you've gotten the answer that you you hoped for. Indeed, these are discussions that should instead be, we should take on these discussions as often as we can, because the little time that we even have for this particular webinar is not enough. There's so many questions that I feel I'd still be able to ask the panelists, but because of time, and as you can see, we are coming to the end of the webinar, I just want to have the panelists give us just a short closing remark, maybe what the lawyers online should take as a take home. What should they do tomorrow morning? What should they do as an action point from this conversation? And we can start with you, Janet. Then we hear from Ridwan. We close it with Mr. Muchivi. And we have Gabriel back again to close it off. Yeah, thank you.
Thanks, David. I think the conversations about AI will not stop. They've started, they're continuing, they're picking up speed, and they'll never stop. The world is very harsh to lawyers who are not upskilling and reskilling. Clients are very harsh to lawyers who are not offering something competitive. They're not offering an edge. They're not offering faster, affordable, well done, well thought out legal services. And that's what AI is here to do. It's not here for you to dump your work, but it's here to assist you do your work in a very smart, seamless, competitive, and this is world competitive outlook. And that's what AI does. Whenever you log in and you're issuing your instructions, it's to give you a third eye, or it's to give you a fourth eye over what you would normally consider your two-eyed vision. So adapt. There's opportunities that will be out there. I've seen somebody talking about legal engineering. There'll be opportunities out there such as AI governance officers, AI policy makers, AI officers, and these are opportunities that will primarily be available to lawyers as well. So reskill yourselves, get whatever necessary certifications you need to get. Immerse yourself in the world of AI. It's quite interesting and it's quite intriguing, and it's never ending. So immerse yourself in that world so that you can become a better lawyer within the region and within Africa and globally. So that's all I have to say.
Thank you, Janet. I think you just took it out of my mouth. I think one last thing I'm just add to this is don't let anybody shame you into using AI. Use it, take responsibility, use it as a companion, use it as an argument, a partner that arguments, but essentially still take the seat as a driver. I mean, they say when you move from the passenger seat to the driver's seat, your view of the road becomes different. So still being able to take that responsibility, verify, because again, you don't want to be part of the data herding to reinforce not stereotypes, but the fact that and I think one key thing is I think older lawyers have benefits of being schooled pre-AI days. And we also have a big risk of people just coming and relying on AI as a source of truth. It's foundational, it's a big problem. But nonetheless, we should leverage, we should use it, we should help, we should see how it can improve what we're doing, but most importantly, think about the responsibility. I think the last thing I want to say is also like a challenge to ELS and also the law society across different member states, which is to essentially look at these issues, use evidence of how people are using the use cases. The judiciary is also like on board, and then use that to then define what a response would look like. Whether it's a guideline, I prefer a guideline because they are softer. A guideline backed by a lot of efforts in investment into capacity. Whether it's going to be some standing rules where a violation of it also becomes a violation of the rules of professional conduct, whatever it is going to look like, the architecture is going to look like, we also need a response. I think we can no longer wait a day more to do the wait and see model. Thanks.
Thank you so much, Ridwan and Janet. Over to you, Mr. Muchivi. Closing remarks.
Thank you, David. Thank you all the panelists, those who are still on the call, and Kenneth who has left, and all our listeners who have been with us for all this long. I must appreciate the East African Law Society for this initiative. It is really something very critical. Gabriel and the group, thank you, and please, I beg, that is not to be a one-off. At least I appreciate it has been a continuous discussion because we still have a lot to do in this area. And I'm thinking that once the bar associations within East Africa take on this aggressively, the policymakers will listen and we've been having a challenge here. I mentioned about it in my presentation when the judiciary wanted to go paperless on 1st June this year in Uganda. PM Digital Law Hub, where I'm a team leader, carried out an online symposium, but before that, it was preceded with an online survey to assess the readiness of a paperless court, paperless judiciary in Uganda. We did it because there was nothing like consultation, something like Janet mentioned that defeated one initiative they had. And for us who are users of the technology and the system, we are seeing a lot not in order. So we took an initiative and carried out an online survey, produced a report to the judiciary and had a symposium where we called the stakeholders, including the judiciary itself, the technical committee, and the interfaced. And I must tell you, after that, we had the symposium around 29th May, and the online, the paperless court was to start 1st June. The dynamics completely changed after that symposium. They changed, and there was a bit of a pause, having seen the results of the survey, which data we had, raw data, we had it properly, and the engagement the stakeholders had about it. And this has now helped the judiciary to rethink how best it can have it, as opposed to the way they were introducing it. This is the only aggressiveness we can have to leverage technology to have it better utilized, inclusive and not exclusive, and also being applied professionally with integrity and also accommodative. And these are things you cannot achieve in a day, or you cannot just pile like projects ordinarily, no. Because even the first world where they started from, there are things they are still fixing here and there. So it's really a very, very serious issue, and it requires united effort. And I know the bar associations can really push a lot. And I just pray that East African Law Society just spearheads these discussions. We shall reach somewhere one day. I thank you.
Thank you so much, Mr. Muchivi. You have said everything that I would have, and even better. I will not dilute the closing remarks of all the panelists. I just want to say thank you to Janet, Mr. Paul Muchivi, and Ridwan for engaging. Maybe to apologize for Kenneth, who was still on transit, and he happens to have logged out before the call ended, but if he happens to hear this, I thank you all for your involvement in this conversation. I find that it's quite timely. So thank you, Gabriel, and the East Africa Law Society. I'm hoping that we can have more of these conversations and we can invite these panelists once again. I think I still have more questions for all of you, but because of the time that we have, please allow us to invite Gabriel to close on behalf of the East Africa Law Society.
Wow, David, thank you so much for that very wonderfully moderated session. It's really kept us on the edges of our seats. And yeah, you could have still shot some of the questions, but given that we are hard spent for time, it's really an honor to host you once again for a subsequent conversation on this area. On behalf of the entire team at the Secretariat, on behalf of our CEO, Mr. David Sigano, our President Ramadan Abubekar, would like to thank you all. You, Mr. David Bahige, Ms. Janet Othero, Professor Paul Muchivi, Mr. Ridwan Oloyede, and in absentia, Mr. Kenneth Mohanji, for this very wonderful conversation. And I would like to assure you all that this conversation does not stop here. It does continue. And I'm happy that one of our conveners, our Honorable Chair for the Data Protection and Privacy Committee, Ms. Janet Othero, was a panelist at this session. So be rest assured that the conversation will continue. We do take AI quite seriously at the society, and that's why we do have an AI policy. And we hope to, champion this conversation across the region, but also across each partner state. So you can rest assured that we'll be reaching out to you, our dear panelists, to get your insights on these issues as we develop a platform for conversation with different stakeholders. To you, our dear participants, we would like to thank you for making time this afternoon. I know it's Monday, it's busy, but we would like to thank you for making time this afternoon to be a part of this conversation. Our YouTube channel, we would like to thank you for constantly supporting, liking, and subscribing on our YouTube channel. If you've not yet subscribed on our YouTube channel, please visit us at East Africa Law Society. Like and subscribe, press that bell and get notified as soon as we upload new content on the YouTube channel. Now, a recording of this session will be shared with you via emails alongside any other presentations that have been made this afternoon. With that said, would like to thank you and wish you all a very blessed afternoon. But before I let you go, I would like to let you know that next week, from the 13th to 17th of July, the ELS Negotiation and Leadership Masterclass will be happening in Kigali, Rwanda. And this 5-day masterclass week will, have very insightful discussions that will be happening in Kigali, Rwanda. If you've not yet subscribed for the same, please visit us at info@elosociety.org. Check out our website, and we'll be happy to send you more information about that training session. So on behalf of the entire team here, we'd like to wish you all a very blessed afternoon. Until we meet again on Thursday, you stay blessed and see you all then. Goodbye.
Thanks, Gabriel. Goodbye.
Thank you.